Advertisements. Have you watched the show Mad Men? It's one of the greatest television shows of all time, an all time classic. The show is all about ads and ad men of the 60s era. Even today, advertisements have the potential to catapult the sales of a product to great heights. There are newer, more far reaching, and less expensive modes of advertising available today, yet advertising is as evergreen as it has always been. So, as a general lawyer dealing extensively in intellectual property and tech law, I deal with a wide variety of issues pertaining to the intellectual property of clients. So, the goodwill of a business is an essential component of its intellectual property and of its brand and value in the market. Now, for all the good that advertisements can do, they have the potential to cause loss as well. Some advertisements are made with the specific motive of tarnishing the goodwill of a competitor brand. This is called disparagement of another brand. Such issues invariably come before us lawyers that deal in IP. Today, I want to talk about a recent case which extensively deals with disparagement by advertisements. This is the case of Dettol versus Santoor Handwash. The official name of the case is Ricket Benixer Private Limited versus Wipro Enterprise Private Limited. The judgment in this case has been passed very recently, this month itself, by the Delhi High Court. I personally found it to be very interesting as this judgment covers a lot of the history on disparaging advertisements and explains how the law was shaped in the subject. I also liked it because it was written by one of my favorite judges, learned Justice C. Harishankar, who passes very well reasoned, thoughtful judgments. I have had the privilege to be on more than one of the judgments passed by him across different areas of law, such as constitutional law and intellectual property law, two of the practice areas which I have quite a lot of experience in. So the case was filed by Dettol against Santoor for an advertisement which they consider to be disparaging of their own product. Disparagement means publishing false statements about another entity's product that hurt or injure its image in the public eye. It is a tort or a civil wrong, very similar to the tort of defamation, or almost like a subset of it. The judgment that has been passed in this case is only with respect to the interim or temporary injunction that had been sought by Dettol and is not a final judgment on the entire case. So, in civil suits, parties file an application for an interim or temporary injunction or restraint order restraining the defendant or the party that the suit has been filed against from continuing a certain act that is allegedly causing harm to the plaintiff or the party that has filed the suit till the case is finally decided. So, the judgments passed on such interim applications for injunctions are often separate from the judgments passed to the entire case, right? And the judgment which I'm going to discuss today was passed for such an interim application for injunction. I intend to make this episode interesting and lucid for the viewers by presenting it in a simple, interesting, and colorful manner so that both lawyers and non lawyers can enjoy and understand it. So, let me first explain the advertisement to you, which led to the filing of the case. The ad showed a little girl who wanted to play with her mother. The mother, however, couldn't play with the girl as her hands were soiled and dirty from gardening. The mother then washed her hands with Santoor Handwash. After this, she goes to play with her daughter, who can't help but awe in pure amazement at how soft her mother's hands have become. While the little girl coaxes her mother to continue playing with her, a voice over announces, "हाथ इतने soft कि छोड़ने का मन ना करे." The mother cuddles the little girl's cheeks affectionately. So at the very outset, the most interesting thing about this case is that Santoor's lawyers had admitted in court that the soap bottle that was discarded by the mother really did resemble Dettol. Yet, the judgment was passed in their favor. You may find this puzzling, but you will find out the specific reasons why the judgment was passed in favor of Santoor by listening closely during the rest of this episode. So, one of the things that a judge does while writing a judgment is discussing past judgments or precedents. In fact, much of the jurisprudence in law in common law countries like India is precedent based. This simply means that new judgments are also written on the basis of past decisions and settled legal principles. Any innovation here only comes in to fill loopholes or grey areas and from the judge's own manner of interpretation in light of changing fact situations and scenarios. So, in this particular case, Justice Harishankar discussed a number of important past judgments on the subject of disparaging advertisements. However, I'll only touch upon those which I'm sure you will also find interesting. So, there was a really famous case of Pepsi versus Hindustan Coca Cola, which Justice Harishankar discussed. In this case, Pepsi sued Coca Cola for disparaging its drink Pepsi in a TV commercial for Thumbs Up. In this particular ad, The lead actor asks a kid which is his favorite drink. The kid mutters Pepsi, which can be seen from his lip movement, though the same is muted. The lead actor thereafter asks the kid to taste two different drinks in two different bottles covered with lids and then asks, "बच्चों को कौन सी पसंद आएगी?" After tasting the drinks, the kid points to one of the drinks and says that it would be liked by children because it is sweet. In his words, he says, "वो मीठी है, बच्चों को मीठी चीज पसंद है." So he discredited the drink, which according to him had a sweet taste. He rather preferred the drink which he felt tasted strong and which he thought that grown up people would prefer. At that point, the lead actor lifts the lids from both the bottles and asks the kid that which was of strong taste, and this is revealed to be thumbs up. Realizing that he had at the initial stage given his preference for Pepsi and subsequently finding it to be a drink for kids, the boy felt embarrassed. He depicts this gesture of embarrassment by putting his hands on his head. So, in this case, the court held that the ad by Coca Cola was indeed disparaging as it degraded the image of Pepsi in the public mind. And the court found that even if the mere statement that Pepsi was for children was not per se disparaging, the overall effect of the advertisement, which included the expression on the child's face, the mocking manner in which it was intoned, "ye bachcho wali hai," the embarrassment displayed by the child, and the placing by the child of his hands on his head, collectively lowered the image and value of Pepsi in the mind of any member of the public who watched the ad or the commercial. The Justice Harishankar then explained the takeaways that he got from reading this judgment of Coca Cola versus Pepsi, which was that the court was required to see the intent of the commercial, the manner of the commercial, the storyline of the commercial, and the message that it sought to convey. He also said that mere puffery was not disallowed. One could claim that their goods were better than that of others. However, an ad which ridiculed or undervalued the product of a competitor or any other brand would be considered to be disparaging. So let me now discuss the reasons that were given by Learned Justice C. Harishankar in his judgment for in Dettol versus Santoor, right? And so he found that the ad by Santoor was not in any manner disparaging of Dettol, and he listed out the reasons in detail. For one, he said that there was no direct reference to any property or trait, positive or negative, of Dettol in the ad. All that the ad showed was that the mother's hands were soft after washing them with Santoor. At most, it conveyed to the viewer that Santoor was superior to other hand wash soaps as it moisturizes skin, and such comparative advertising was in fact permissible. Next, he said that Dettol was reading too much into the ad to think that it disparaged the product. The ad did not say anything about the moisturizing qualities or lack thereof in Dettol. It merely praised Santoor for having such qualities. He then went on to say that the little girl's reaction in the ad of finding her mother's hands to be soft was simply a spontaneous reaction of a child. It could not be interpreted to mean that the mother's hands were not soft before she used Santoor, and at most it showed that they were simply softer than before after using Santoor. Then, one of the most important points discussed was at the part of the ad where the mother replaces the older soap bottle resembling Dettol with the Santoor Handwash. So the judge was of the view that this part of the ad was merely for 2 seconds, out of the total 35 seconds in the ad, specifically from the 25th to 27th second. The judge also pointed out that it is very common for a person to discard an old soap when buying a new one and that there was nothing shocking in such a scene. Now, about the admission by Santoor's lawyers that the soap bottle discarded by the mother in the ad did resemble Dettol, which I had referred to earlier in this episode and asked to listen till the end to find out the answer. Justice Harishankar said that although such an admission had been made, it was immaterial what the intent of the advertiser was, and all that mattered was what the ad actually conveyed and not what it intended to convey. So once again, since the ad did not in any manner denigrate or disparage Dettol, it was legally considered to be valid. So these were the main reasons in the judgment for denying the grant of injunction to Dettol and allowing the ad to continue being aired. It had been clarified in this judgment that the views expressed are only with regard to the application for interim relief or injunction and will have no bearing on the final decision of the case after listening to the arguments at the conclusion stage of the suit. So I hope you enjoyed today's episode and learned something new from it. Stay tuned for more exciting episodes about IP and tech law developments in India and around the globe. Have a great day. Thank you.